National Accountability Bureau Ordinance, 1999. The National Accountability Bureau, NAB, was established in 1999 by the then military government for curbing the overwhelming rise of corruption in every public sector department during the tenure of the political governments in the preceding decades. NAB was vested with a wide range of powers in the matters of arrest, investigation, and prosecution. Establishment of NAB started a new era of anti-corruption mechanism through a three-pronged strategy: awareness, prevention, and enforcement, which were introduced as totally opposite to the past practice, merely relying on enforcement-oriented measures. The promulgation of National Accountability Ordinance was a step forward to make efforts to eliminate corruption and corrupt practices, to provide effective measures to the society by setting up an institution of National Accountability Bureau. The National Accountability Ordinance repealed the Ehtisab Act, 1997, and all the pending proceedings would be transferred to the NAB from the date of promulgation of the ordinance. The Prevention of Corruption Act was the first legislation in an effort to eradicate corruption from the country. This act is still in force, but failed to achieve the objectives. Then, the federal government in November 1999 promulgated the National Accountability Ordinance. The act was made applicable not only to public servants, but its scope was extended to holders of public office and persons involved in corporate business. Powers of Chairman NAB. The Chairman NAB has powers to order the arrest of the accused. The accused must be informed of the grounds of his arrest. Powers to seek assistance. According to Section 27 of NAB 1999, the Chairman NAB has the power to seek full and complete assistance and call for all or any documents and information relevant to or in connection with any matter or proceedings pending before the NAB from any department of the federal government, provincial government, local authority, bank, financial institution, person, or any authority and institution or department in the public sector or the private sector, as he may deem fit and proper to demand or require, provided that in any case in which a question of secrecy is involved or is raised at any time, the chairman's decision shall be final. Powers of the court to freeze property. If there appear reasonable grounds for believing that the accused has committed such an offense, the Chairman NAB can order the freezing of his property, movable or immovable, or part thereof, whether in his possession or in the possession of any relative, associate, or person on his behalf. The Accountability Court has exclusive jurisdiction to entertain and adjudicate upon all claims or objections against the freezing of any property under Section 12. Such claims or objections are made from before the Accountability Court within 14 days from the date of the order freezing such property. International cooperation request for mutual legal assistance. The Chairman NAB or any officer authorized by the federal government may request a foreign state to cooperate in accordance with the law of such state, to have evidence taken or documents or other articles produced. Punishments for corruption and corrupt practices. A person who commits the offense of corruption and corrupt practices is punishable with imprisonment for a term which may extend to 14 years, or with fine, or with both. And such of the assets and property of such person which is found to be disproportionate to the known sources of his income, or which is acquired by money obtained through corruption and corrupt practices, whether in his name or in the name of any of his dependents, or benomidars, shall be liable to be forfeited to the appropriate government. Voluntary return and plea bargain. Where before the commencement of the trial, or at any time thereafter, with the leave of the court, the holder of a public office or other person accused of any offense under this ordinance voluntarily returns to the NAB the assets or gains acquired through corruption or corrupt practices, and discloses the full particulars relating thereto, the Chairman NAB may release the accused person with the leave of the court, or proceed with the trial subject to such conditions, if any, as may be imposed by the court. Narratives about plea bargain. The critics of plea bargain say that it is actually a license for white-collar criminals to commit crime. The critics say that since the main emphasis of ENB has been on plea bargains to pocket hefty amounts as share out of looted funds, the offenders remained unpunished. National Accountability Bureau Ordinance, 1999. The National Accountability plea bargain. The critics of plea bargains say that it is actually a license for white-collar criminals to commit crime. The critics argue that since the main emphasis of NABE has been on plea bargains to pocket hefty amounts as share out of looted funds, the offenders remain unpunished by paying peanuts. On the other hand, NAB claims that the investigation and prosecution of white-collar crime cases is too extensive, expensive, and securing convictions is also difficult because of the accused's access to high-profile lawyers. Therefore, plea bargain is seen as a viable option to recover some money. NABE's perspective about its performance. In a report released in response to allegations by politicians of character assassination and campaign for tarnishing of image, NAB claimed an impressive overall performance, with a prosecution rate of 70% and not 7% as claimed by the Prime Minister. NAB claims to have recovered more than 300 billion rupees since its inception.